Good morning. We're waiting for folks to join the call. We'll get started in just a few minutes. We have a few more folks who are joining the call, so we'll get ready to go in a minute. All right, we're going to go ahead and get started this morning. Good morning. My name is Anna Dowdy. I'm with the Florida Association of Counties. We're so pleased to be here with you today in the Florida Association of Counties Trust. Welcome to the third installment of the FACT 2020 Risk Management Conference webinar series. Before we get started, we got a few housekeeping items. If you have any questions, please type them into the Q&A function in the bottom of your Zoom. So please type those into the Q&A function. And at the end of the presentation, we'll circle back to those questions and make sure that we get everything answered. Also, if you're interested in SHRM hours, please contact Kim Morgan at the FAC office, and we'll be sure to get you a certificate of attendance for your files. Today, we have with us two attorneys from the Warner Law Firm in Bay County, Florida, Alicia Carothers and Eric Krebs. Ms. Carothers primarily practices civil litigation defense, representing cities, counties, and sheriff's offices throughout Northwest Florida. Prior to joining the Warner Law Firm, Alicia was a felony prosecutor with the 14th Judicial Circuit in Florida. Alicia received her Juris Doctorate from Faulkner University School of Law in Montgomery, Alabama. She graduated from the University of West Florida with a bachelor's degree in psychology and a minor in social work. Alicia is a member of the Florida Bar's Unlicensed Practice of Law Committee for the 14th Judicial Circuit, as well as a member of the Florida Bar's Governmental and Public Policy Committee. Alicia spends time outside of work volunteering with the Junior League of Panama City, where she sits on the board of directors. Mr. Eric Krebs also primarily practiced civil litigation defense, representing cities, counties, and sheriff's offices throughout Northwest Florida. He is licensed in Florida and Texas and attends Texas A&M School. He attended Texas A&M School of Law. He attained a Master of Music Performance from the University of North Texas and a Bachelor's of Music Education from the University of Southern Mississippi. In his free time, he's the secretary of the Kiwanis Club of Panama City, the principal percussionist for the Panama City Symphony Orchestra, and an adjunct professor of music at Gulf State College. At this point, I will turn it over to Alicia and Eric for their presentation.
Thank you very much, Anna. Good morning, everyone. As you heard, my name is Eric Krebs. Today, we're going to be discussing some issues related to playgrounds and parks and so forth. I want to start today with a short video, and then we'll get into the program. So.
Excuse me. There's a sign at Ramsett Park that says do not drink the sprinkler water, so I made sun tea with it and now I have an infection. Sir? Sir, are you listening to me, sir? Sir, I'm talking to you. Sir, are you aware that there is waste in your water system?
That's a clip from Parks and Recreation. I'm sure a lot of you will probably run out and try to get that desk so you can possibly do what Ron Swanson was doing in that. She mentioned that there was a sprinkler that said, do not drink the water, so she made tea out of it. Sometimes you can't help people. Today we're discussing, the name of our program is Slide Snakes in the Law. This is issues with playgrounds and how to protect the children and yourself. It's intended to be an overview, primarily of issue spotting, not a definitive guide to issues related to playgrounds. However, I hope after today you're able to take this information and discuss it and discuss these issues with the powers that be and those in the position in your counties to maintain and supervise these areas. At a minimum, if you haven't had your parks and playgrounds inspected recently, this may be a good time to have that done after the program. I want to start with some pictures of sort of what not to do. These are all over the world. This, as you can see, is probably not the best place to put a slide. This looks like something that would probably cause some issues with with gravity. We've got this, positioning the playgrounds are often a difficult situation, but this is probably not the best place to put a bunch of slides on top of a building. In Russia, they want to make sure that the children cannot escape, apparently, so they put barbed wire around their playgrounds. Probably not the best thing to do. Also, how high your slide ends up falling is probably something to look at. This is definitely an extreme. And then also make sure that there's actually a place for your slide to end other than trees. And, this is something to deal with. Probably not the best place to put a swing set. Just a little personal experience with historically bad playgrounds in the 70s. I'm a child of the 70s and 80s. I'm sure any of you that are around my age or are familiar with the unbelievably hot metal slides that existed. Typically just a very large surface area. In the South, obviously those get up to be 100 degrees easily, and I'm sure everyone's had an experience of significantly uncomfortable experiences with those metal slides. Also, in my elementary school, we had a tall jungle gym that was probably 10 feet tall, and it was over concrete, so probably not the best way to deal with that. And when I was little, at a military base in Mississippi, we had a playground set up in base housing that was right next to a ditch. And the ditch included crawfish and water moccasins and snapping turtles. We used to play with the snapping turtles with sticks and try to make them chomp on the sticks. We used to get the crawfish and have them fight each other. Probably not the best thing to be doing as a 5-year-old, but probably not the best place to put a park either. So just some ideas. So with the extremes out of the way, let's talk about some of the statistics regarding injuries. The CDC, these are from their recent website. It states that 56% of the playground-related injuries that are treated in emergency departments are fractures and contusions, bruises or cuts, and about 75% of those injuries are related to playground equipment and occur on public playgrounds, most of the time at a place of recreation or school. Traumatic brain injuries are also about 2/3 of the playground-related traumatic brain injuries occur at a school or places of recreation, and often involve monkey bars, climbing equipment, or swings. Most emergency department visits occur during the weekdays, Monday through Friday, so a lot of that's school probably. And then playground-related traumatic brain injury emergency department visits occurred frequently during April, May, and September. I'm not sure why. I guess that's probably when the weather's the best, so the kids are outside playing. Between 2001 and 2008, there were the CDC, the Consumer Product Safety Commission investigated 40 deaths associated with playground equipment, and the average age of those that died were 6 years old. Of these, 27 died from strangulation and 6 died from falls to the playground surface. And strangulation often involved a combination of slides with the chains of swings, jump ropes, dog leashes, clothes dryers. But for a public park, primarily the slides and the swings would be the things that we would look at. There are particular injury risk factors that the CDC has found, and while all playgrounds are at risk to cause some injury, boys sustain treatment slightly more often than girls. I wonder why. Maybe because they play with, they tend to play a little rougher, or jump off of swings at high, like we used to do when we were kids. Unfortunately, luckily nothing was ever broken. Children ages 5 to 9 have a higher rate of ED visits for playground injuries than other age groups, and most of these occur at school. Public playgrounds, the issues are with monkey bars, climbing equipment, and a lot of that has to do with surface areas of where they would fall if something happens. Like I discussed in my elementary school, we had a 10-foot tall monkey bar with just concrete below it. So probably not the best surface area for a kid to fall from 10 feet. Playgrounds that are well maintained, though, have fewer risks to children. So if there's rusty or broken equipment, if that's eliminated, that helps tremendously on preventing injuries. Again, with traumatic brain injuries in playgrounds, the youngest are typically injured on swings and slides. As they get older and they start climbing, then we have monkey bars and climbing equipment to deal with, and it goes on from there. The older they get, also, this happens more frequently at schools and not necessarily public parks and public playgrounds. So let's talk about getting into a playground. There's different types of playgrounds, and when you're discussing with your county if you want to do create a playground, I think they're good for the community if they're done safely and if they're done with some thought. There's lots of them around. It's good for the public to have places for the children to play. And so it's just important that the planning is up to snuff, for lack of a better term. But you also have to determine what kind of playgrounds you want. Traditional playgrounds are very popular. They're also typically easier to construct. We've got water features, potentially splash pads. I know there's that's getting really popular in a lot of areas, which has their own issues to think about. And then there are some companies out there and a movement towards creating parks that are for developmentally disabled children, so they can participate. And so there's different ways to do that as well. And there are some places that have a combination of all of these elements. One of the things to think about is where you're going to locate it, and make sure that where you pick, unlike some of those pictures we showed, is a place that is safe and a good environment for a playground, not next to a ditch that contains a bunch of water moccasins. Would probably be a place to avoid. There's a lot of good resources, though, for counties to look at for construction on this. And it's important that whoever is designing these playgrounds looks at these types of resources. The Consumer Product Safety Commission has a checklist for creating playgrounds and playground safeties. They have a handbook for safety. They work in partnership with the company kaboom.org, which is a national nonprofit organization committing to building safe playgrounds. So they've worked with the Consumer Product Safety Commission for this handbook and these checklists on how to safely create and maintain playgrounds. There's also the American Society of Testing and Materials. This is the very precise engineering diagrams and guidelines for creating safe playground equipment and parks. There's also the National Program for Playground Safety. They've got a lot of good resources on creating and maintaining public parks and safe playground equipment. And then if you're doing some of the, like a water park, for instance, has to have specific things that meet the Florida Department of Health related to the water that is used. And so there is a water in the Florida Administrative Code, Chapter 64E-9 has a lot of information related to water features and what is required. There's also things on the Department of Health's website related to construction plans and standards. So this is just a few that I found that have just a range of information related to safety and creation of safe playgrounds and parks and water features. So if the person that is creating the plans for the park is not familiar with parks, because I know a lot of counties either have their own engineering department or they use someone else, make sure that the engineer is familiar with this. If they're not, they need to do some research and make sure that what you're creating and what they're planning to send out for bids is actually going to be appropriate and safe according to some sort of guidelines. And I think that would be a way to protect the county in that system, so that the planning aspect is done correctly. And part of that planning is, how are you going to, the surface areas are one of the main issues with injury. Is it going to be rubber, synthetic? Are you just going to use mulch or mats? There's hygienic issues related to water features, but also if you're using water, rubber mats or so forth, how are those going to be cleaned and maintained so the bacteria and other slippery substances in addition to the water isn't on there that makes it worse. Tripping hazards, that's one of the leading causes of injury. So if you're going to have a park of some sort, make sure that everything is not where, if a kid runs, even though they may not supposed to be running, they're not going to trip on something that would cause damage to them. And then, the facilities and equipment, this is one of the biggest things. You make sure that what you're building is easy to upkeep for the maintenance people in the county, and make sure that the equipment that's being created is intended to do things safely. Kids will climb pretty much anything that they can climb. So the things that they try to climb need to be maintained and created in a way that they were intended for that. You can't prevent everything, of course, but the best that if you try to make something as safe as you can, that will help in liability situations later. And Alicia will be discussing the liability side of things later in the program. So building concerns, this is what I mentioned earlier. You want to make sure that the contractors, when they're building these, so you have your engineering department do the plans, put it out for bid, make sure that the plans are developed in some sort of guideline and safety. Make sure that the contractors that are bidding on this are familiar with the playground construction and that they've done these things before, or they're somewhat familiar and able to do it correctly. There's been issues where surface areas are done incorrectly, and that can cause a problem later if they come loose or some sort. And if that's a construction defect, then that could be a problem. So you want to make sure that your construction is done correctly and that the people are familiar with these types of things. It's different from building a house or a building as opposed to a water feature. So you want to make sure that whoever's doing that knows what they're talking about and knows how to do it. And if there are defects in construction, make sure that they are fixed before you open the park, before you open the playground, as best as you can. Obviously, if there's things that are hidden and no one knows about them, that's a different situation. But if there's anything that can be detected, don't rush the opening of a park for a deadline just because you want to open a park for a deadline. There's no reason to avoid safety because of a calendar. So now, after the construction is completed, this is probably the most important part. I would assume that everyone on this call has playgrounds and other features in their community that are already completed. And so, the biggest thing here is, what kind of signage do you need? What to include? I know the CDC requires some things or has a model aquatic health code that talks about some of these signage things. The Florida Department of Health has some requirements or suggestions for signage on water features and playgrounds. You want to make sure that if you are going to have supervision, that's one of the things you want to talk about. If it's an open playground to the public, is it closed at certain times to prevent people from getting there when they shouldn't be? Are you going to have someone supervising? Obviously, if it's not a pool, we're not talking about lifeguard situations, but are you going to have someone nearby that can be reported if there's an issue or a problem, or phone numbers for people to call? So, the more supervision or ability to make sure that there's some oversight of some sort, or at least enough signage to realize that this is not being supervised, with enough maintenance checking out on a regular basis to make sure there's no issues with the park, testing the pH levels in the water daily, testing, different issues related to that. That's the main issues that you want to think about, is upkeeping. The National Program for Playground Safety has this SAFE. It's an acronym, and really this sums up a lot of what we're talking about. You want to talk about supervision, whether there needs to be supervised children there, signs requiring adult supervision. Maybe it's not a county employee, but you have enough signage saying that you have to have parents present for certain age levels. The appropriate environments we discussed, fall surfacing, and the equipment maintenance. So this acronym basically sums up what in an easy to remember manner, the problems associated with playgrounds and such that can prevent issues, hopefully, from the county. So with that being said, once everything is created and put into place, then we have to deal with what kind of legal issues that arise from a playground. So I'm going to turn this over to my partner, Alicia. And Alicia, just let me know when you want to change the slides.
Sure. Good morning, everybody. So very simply, the premise on the screen that the municipality is not an insurer of those who use the public parks. The municipality's duty in such case being only that of exercising due care under the circumstances. That's a little bit of formal language, but a lot of the cases that we're going to talk about, as you can see on the screen, those are from the 40s. The other cases I have that we'll talk about are not really that much better. I'm sure there's a lot of litigation going on regarding injuries at parks and playgrounds and that sort of thing, but there isn't a lot of, there clearly aren't a lot of appeals that are going on, which I guess means that there is potentially some reason that these cases are getting resolved and they're staying that way. But just like that says, very simply, a municipality has a duty to maintain its parks, its playgrounds, what have you, in a condition reasonably safe for public use. And I think that that is common sense. I don't think that's a surprise to anybody. If you're, as a county or a city or entity, if you are going to create an environment that people are going to come to and want to come to, then you also have a corresponding duty to make sure that that area is safe and maintained. However, it does not walk to the level of a strict liability issue. Every single injury, fall, anything that happens in a park or a playground is not necessarily going to create some sort of liability on behalf of the city or the county. So there is a limit to that. So looking really at the Lisk case, which is listed there, Lisk versus City of West Palm Beach. This is actually an interesting case. It involves a public park. You beat me to it, Eric. Not yet. In this particular case, it actually involves someone who is in a public park being maintained by a city, and the park had coconut trees that had been planted. At least they were described as coconut trees in the case, but it references actually a palm frond that broke off and fell and hit the individual sitting beneath it and caused injuries. So it must have been a pretty substantial palm frond to have caused some sort of injury to someone. But essentially, the individual was arguing that it was the city's responsibility because the palm frond broke off. And the court walks through this analysis of, really what is the duty of a city or a county entity, municipality, regarding other types of things that are in parks. So not the traditional thing in a park. So not a bench or, a slide or something like that that might have some inherent danger, but something seemingly innocent like a tree or a plant or something like that. And the court went through an analysis looking at what type of notice would the city have been on. And I think this case is actually really important for those of us in Florida because we deal with hurricanes and all sorts of weather events often, and those sort of wreak havoc on our public places. And so I think it's important to have some sort of process that's kind of delineated to really determine how the city or the county is going to address your public spaces after a significant or even non-significant type weather event. And we can tend to get those pretty often in Florida. So it's certainly something to consider. But that was one point that the court made was what sort of notice would the city have been put on? And in this particular case, that there was some argument as to whether it was a dead and dying tree versus whether it was just some freak accident. So, but I think this kind of goes to a second point here, which is record keeping. I think it's important, you know, in these types of instances to know what is your record keeping regarding upkeep, maintenance, care, that sort of thing for the park itself, the items that the city maintains inside the park, whether it's just simply benches, whether it is some sort of vegetation, lots of trees, or whether it is slides and swings and that sort of thing. Do you have a subcontractor that you employ who is going out and maintaining these things for you? Are they keeping records? Are they noting down the dates and times where they're simply doing a checkup, or they are actually fixing something, and then the act that they took to do that particular maintenance? Were they replacing something? What did they replace it with? That sort of thing. All of those things are questions that we are going to be asking if litigation ultimately does result from an incident in a park. We're going to be asking for records. We're going to be asking who are the individuals who are going out and doing this work in the park or the playground. And so it's certainly something to consider. With the Ide versus City of St. Cloud case, I'll skip to the third case listed here. The duty to maintain the park or the playground can actually extend to a location that's outside of the city limits. In that particular case, a city was maintaining a park outside of their city limits. I don't know why the City of St. Cloud would do something like that, but they did. And there was a lake type swimming area in that particular area where someone drowned. So the court said that, you know, you're maintaining a park outside of your city limits. You don't really get to pick or choose. The things inside of that park are also going to be your responsibility. So it's important to think about if you're, you know, going to, you know, just be really nice and decide to maintain something outside your city limits, that you're going to be putting yourself in a position where you could be facing potentially additional liability. So we will move to the Pickett case. Eric, if you want to go to the next slide. And this breaks down a little bit the Pickett versus City of Jacksonville case, again from 1945, but still a good premise. In this particular case, there was a question regarding a swimming pool. And as you can imagine, a swimming pool, we have one here in Panama City Beach. We have a very, very large park on the beach, and part of that is a very large swimming pool. And the court essentially came right out and said that absence of a lifeguard at a swimming pool is negligence. If that pool is going to be open to the public, and that is going to be a pool that you are going to maintain and take care of, clean, that sort of thing, then you also need to provide the mechanism in which safety can be ensured in those situations. And that in this case would be a lifeguard for that particular swimming pool. But again, it does not necessarily mean that you are insurer of all safety to the patrons, which we'll talk about actually in the next case, which is Payne versus City of Clearwater. And again, another case from the 40s, but in this particular case, we kind of see that next step where the court says, okay, we're going beyond what is the city's responsibility. In this particular case, and I don't know why anyone would do this, but the defendant city, Clearwater, maintained a springboard that was attached to a pier and extended out over the edge of the pier into the Gulf of Mexico. Again, I don't know why anyone would create something like that, but they did. And it was used often, as you can imagine. And the springboard itself and the pier were maintained by the city. But the way that the springboard was actually created, it became, as you can imagine, wet and slippery whenever someone would dive off of it, and then the water would splash back up, or people would, dive, run back up, and so it just became wet, and that was, that was natural, of course. So the plaintiff slipped off of the springboard, which I kind of imagine to be like our traditional diving board that you think of on a pool, and slipped and then fell and injured themselves, himself or herself. And ultimately, the springboard was alleged to have been unsafe and dangerous. But the interesting thing about this was that the court kind of determined that the springboard was really only unsafe or dangerous when wet. That seemed to be the only thing that was really being taken issue with, was that it was dangerous or unsafe when wet. That when obviously water would splash on the board when the diver would dive. The slippery condition then was incident to its use, and they couldn't find that the defendant city was negligent under that particular set of circumstances, because one would expect that a springboard that's very close to water, that's being used often by lots of people who continue to dive and then run back up and dive again, will get slippery and will get wet. And so that's one of those instances where the court said, okay, we're not going to extend liability to the city because that's going to be a clearly obvious, potentially dangerous situation to the user, and that the user should then ultimately take more care in their use of that item. There wasn't anything that they could really extend to the city from there. Again, I'm not really sure a springboard over the Gulf of Mexico off a pier is a great idea to begin with, but that was the situation in this case. So, like I kind of said before, a lot of the cases are very common sense in a way. It repeats the common thread of, if you're going to create an environment where people are going to want to go and spend their time, which is reasonable, people want to spend their time outside playing in parks and on playgrounds and that sort of thing, swimming or being on a splash pad, make sure that that particular location is being created in a safe manner, and it's being maintained in a reasonable manner, so that, and of course, with the requisite record keeping, to make sure that on the back end, if something does happen, if an injury does occur, that you have really kind of put yourself in a good situation where there potentially could be little to no liability on behalf of the city, county, municipality, whoever is actually creating that environment. All right, Eric, I'll tag back out to you.
Sure, thank you. So this up here on the screen, it says knowledge is important. So for a county to be liable, an injury must be from there must be actual knowledge, or there should have been it's been so open and obvious that the city or the county should have known that there was a problem. So, regular maintenance and regular visits to these locations to determine whether there's rusty nails, rusty conditions, problems with loose equipment, whether the surface areas have been extra slippery, things of that sort. And once something has been determined to be a problem, it needs to be corrected. And there needs to be documentation, as Alicia said, on all of this, on the creation, on the planning, on the building, on the maintenance of it. There needs to be a way for someone to contact the county or this when there's an issue, and there needs to be some follow-up documentation. If there's some documentation that a problem has arisen and someone has complained, there needs to be, unlike Ron Swanson swiveling around trying to avoid the lady, there needs to be somebody that is actually taking notes and has taken that problem and assigned it to somebody, and that somebody has gone out to look at it and they have fixed it. And all of these steps need to be taken, but they also need to be documented, because we can't rely on, oh, well, Joe Bob went out and fixed it, we think, but he doesn't work here anymore. So we're not really sure if that happened when we told him to do it, but we need documentation. You need documentation on all of these things. And it's mind-numbing paperwork, but it's important. And they don't, it doesn't have to be, I think, as defined as, what particular, screws were used to fix the equipment. Although that would be great, the more detail, the better. There needs to be, at least Joe Bob went out on this date and looked at it and determined that there was this problem, or went out and looked at it and there wasn't a problem, or went out and looked at it and fixed the problem. And, or if they couldn't fix it now, we've shut the park down in that area so that we can fix it. Signage has been put up. Do not use this equipment. There's things that need to be taken care of. A real world example that we're dealing with right now is a unnamed city. We know who it is, but an unnamed city created a splash pad. Again, they're very popular. There were some complaints at the splash pad about people slipping, and there were some Facebook messages of, all right, the kids are slipping. Well, it's a splash pad. You may think that kids would slip. There were signs that said don't run, and parent supervision and so forth of this splash pad. The city manager made a public comment on Facebook about the slips and said, quote, they were looking at the possibility of some non-slip adhesives for the areas where the kids typically fall. So he admitted, hey, we know this problem. He put it out to the world, and we're looking at ways to resolve it. Although the city didn't do anything, and there's no documentation that they actually looked at any issues or if there was any kind of ways to change it. There could have been documentation, preferably some documentation that said, all right, we did a study on what we have versus what we could have, and we've determined that there's not a significant difference, or there's not, what we have is sufficient as, for what the conditions are. We don't have any of that. So what they did instead was they created a second splash pad after all of this and used the same materials as the first. The city didn't have supervision at the splash pad area at the time the park was opened, although there was someone located in the park. They weren't directly next to it, but at the time this happened, no one was there to witness it. So we don't have any witnesses, but a fall occurred, injuring an 8-year-old boy. And thankfully it wasn't permanent, but he did have some initial bleeding on the brain. It was very significant cut on his head, required a lot of stitches. There was no witnesses to this fall other than the grandmother who called the city a couple days later about it. After this happened, they did find and did some research, and they did resurface the areas where he fell. And so now they're suing the city for negligence related to the surface areas being slippery in a water feature. What could have been done differently? A lot of this is, if I would suggest, probably not going out on Facebook and saying, yes, we know people are getting injured and we're going to look at it, and then don't do anything. I mean, that's probably the worst part of this case on a liability situation. Oddly enough, there have been no reported slip and falls at the previous splash pad. So they haven't been put on notice that they had issues at that one as far as anything significantly injuring someone. So, I mean, that's positive, I think, for the city. Maybe that surface area was appropriate. That's something we're trying to figure out, but we don't have any records that show that they actually looked into this until there was a significant injury, and then they were looking at ways to fix it. Was the kid running when he shouldn't have been? Was he climbing on something? All of this is stuff that we don't know yet, and we're trying to determine. So it may not even have been a slip and fall, but if it was in some other situation, and we would suggest not making these public comments that we know and we're looking into it without actually looking into it and trying to do something. So that just goes with the knowledge aspect of it. With that, I think we're to questions. So let me figure out how to look at these questions and go from there. Do I need to unshare now? All right, looks like we have 2 questions. First one, is there a protection for older playground equipment that may be serviceable but not up to current safety standards? For example, equipment that was installed over grass rather than a surface that allows for current impact standards. I think if the equipment is being maintained safely and the grass, there is some inherent danger, I think, with any playground equipment. And what the cases Alicia mentioned was, as long as they are being kept in a reasonably safe manner, that may be okay. I think really grass, that's more of a question of fact. What was the injury? What was participating? Obviously, if the playground equipment was not kept up and it tips over or causes some injury or the chains break or some sort of issue arises from that, that's different. But, you know, it's something to look at if you're concerned or you've had some complaints about the grass being too hard of some sort. It may be something to look at in that respect. Alicia, you have anything to add on that?
No, not really. I think you could also potentially look at, if let's just say, you're looking at having to maintain swings. I'm thinking of a particular park that was near my house growing up, and the chains were always rusted because they were metal, and the seats were very thin rubber, and the rubber was always like cracking from, being in Florida and weather and that sort of thing. So even though those are older materials, I think it could be potentially cost effective in the long run if an entity or city, county was to determine that, let's upgrade some of these items, and that will give us not only maybe, a little bit more of a liability buffer because we're upgrading to current safety standards, but also it may be cost and time effective for your employees. You're not necessarily having to send someone out there all the time to address rusty chains or cracking rubber seats, and you're, maybe buying those items over and over again. Excuse me, if you were to potentially upgrade to something with a new material, it would potentially be less maintenance for you, less repurchasing of items, and also have the added benefit of being up to a current safety standard. So it may just kind of be a cost thing to look at too, and could potentially end up being a money-saving option in the long run.
And then the next question is sort of similar to that. It says, what's the difference? Is there a difference preferably between making homemade repairs versus replacement parts from the manufacturer? Well, there's a lot of questions about that brings up in my mind. There are a lot of new companies out there, or more recent companies that create these very elaborate playgrounds that are designed to be safe of some sort. And if they have products that, they're probably warranted to an extent, you may, if you're within the warranty, obviously you want to contact the manufacturer and make sure that they are doing as much as they can, because that puts the liability potentially on them as well. If there's a problem with one of their parts that was defectively made of some sort, that creates an issue for them. And that may be something to steer the liability on as far as a warranty situation. Now, there may be some other legal indemnification issues that result from that, but I don't want to complicate the matters for today. For older equipment, homemade repairs, obviously, if they're not within warranty or the company's not around anymore, you can't get the, I think as long as it's reasonably upkept and it's in a safe condition, and there's documentation related to it, I think that it would be okay. Again, there's a lot of crazy, really nice playground equipment that is expensive, unfortunately, but you can also work, and this is something you can do. Like, I'm in Kiwanis Club, and we haven't done it here, but I know that the Kiwanis Clubs nationwide have this program where they work with cities and counties and this playground manufacturer, and they raise money and they put in these really neat playground throughout the world, really. So there's a way that the county and the city could actually partner with a nonprofit or community organization to help with these endeavors and help with producing and maintaining, even possibly with a playground of some sort. But there's a lot of options out there for people. Luckily, we have the internet age, so it's all just a click away as far as getting information, which also is a sort of a two-edged sword. There's a lot of information out there. So if you haven't looked, and it's, you have an engineer that has never done a playground, and you have a construction company that's never done a playground, that could possibly cause issues, because there is a ton of information to determine what is safe and what isn't. And that helps protect the counties from any, potential liability in that respect. Are there any other questions that we have?
Just a question for you, Eric and Alicia. In the COVID area, obviously, parks are becoming more and more popular. Folks are, going outside. They're wanting to be outside. Are you guys seeing any uptick in the number of claims that are made concerning playground equipment, or has that cycled around yet? That phenomena of, because it's being used more, there's going to be more opportunity for incidents to occur?
I haven't seen it. I would think that if it's happening, we would probably get some notices from a certain attorney in Tallahassee pretty soon. But I haven't seen that yet. I know that there are a lot of CDC guidelines related to parks that the counties probably should look at as well, and make sure that if there are things that can be wiped down on a regular basis that are not to the sun, interior areas of a park, for instance, that don't get the sun, because it seems like the sun kills a lot of germs and coronavirus very quickly after a limited amount of time. But if there are interior clubhouses and stuff that don't have that protection from the sun, that may be something that they want to look at. But I haven't seen anything, Alicia. I know our firm hasn't really been hired to do any of that.
And if there was do counties need to consider, like if you had a maintenance schedule beforehand because you expected 100 people to go visit that park on a weekly basis, and now folks are trying to get outside, and so now you have 200 people that are going to visit that park on a weekly basis, do they need to consider that maintenance schedule and responding to the fact that there's just going to be more people and therefore potentially more wear and tear on the equipment, and trying to do a different type of maintenance schedule?
I would think that would be wise. The use of a park should be factored in with the maintenance schedule and the supervision schedule. I know that the city was doing that. We were talked about earlier with the splash pads. They had someone that put eyes on the equipment every day, and had someone put eyes on they checked the pH levels in the water to make sure there weren't any kind of bacterial issues on a daily basis. So there was, if it's used more often, like a regular playground, then obviously the wear and tear may happen quicker. So you would want to make sure that you have eyes on during that.
Okay. All right. Well, thank you so much. Kim, do you want to throw up the final screen with our information? Thank you so much for Eric and Alicia today for being a part of this webinar. We greatly appreciate it. If you all have any questions, obviously you can direct them straight to Eric or Alicia. Kim, do you have their contact information? At the Warner Law Firm in Bay County, or you can direct it to Kim and I, and we will make sure that those questions get to them. We have recorded this session, so if you have folks that are out in the field or those types of things, but you'd like to show this to them at a later date, we have recorded it, and so we'll put that on the website. Or again, you can get in touch with Kim in our office, and she can shoot you a link to the webinar. Our next series of webinars, we have one on next Friday with Bill Krisner with the Krisner Group. And so we hope folks will get registered for that to attend. And then the 2021 Fact Risk Management Conference is scheduled for St. Johns County. We very, very much want to be back in person as soon as possible. Certainly that conference next year is scheduled to be in person in October of 2021, but we're also hoping to get our roundtables back in person beginning hopefully in January of 2021 as well. If you are interested in SHRM hours, also get in touch with Kim, and she can get your certificates of attendance for those SHRM hours. Kim, did I forget to say anything? Was that it?
I think you covered it. I think we're good.
All right. Well, thank you so much, and everyone have a wonderful weekend.